Mary Brecken is a senior associate in the employment team at Simpson Grierson and is here to talk about the latest and most interesting employment law in this week's Toil and Trouble Employment Law Wrap. Mary, thanks for coming in. Now, let's talk about Uber. This is a long-standing sort of issue about contractors versus employees. Tell us about the latest.
Sure. So the Uber case finished in the employment court just last week with Chief Judge Ingalls, who has presided over the case. And Dita, it must be a feeling of deja vu for Uber, who have had the classification of their workers challenged all around the globe, and even more so here, as this is the second time that Uber has been through the employment court process over whether its drivers are employees or independent contractors.
Right, and so what was the finding?
So that was in 2020, and the employment court found that Mr. Arachechej was an independent contractor and not an employee.
Okay, and so what happened last week? How did it take it on?
So the employment court has reserved the judgment in terms of this new case that's going through the employment court at the moment, and that's the applicants in that case are actually the union. So the union are arguing that the drivers are employees, so effectively they can unionise.
Okay, so is this trying to settle once and for all, not just for Uber but for all these sort of courier companies and so forth that have a similar structure? Is it trying to sort of make a case that's a precedent for everyone?
The court isn't bound by its own decisions. In New Zealand, it's only bound by those courts above it. Okay. So the employment court and the judge in this case will be persuaded by that earlier judgment, but not bound by it. So in this case, she will be assessing the facts and inquiries under Section 6, which is the section that's relevant when assessing or determining whether an individual is an independent contractor or an employee. Under that test, it is intensely fact-specific. So this won't be a precedent that the taxi drivers or the courier drivers in other circumstances can pick up and say, we're also employees because of that decision.
Oh, so it won't be. So this could see many such cases then happen, maybe encouraged or spurred on by this decision if it goes in their way.
Yeah, I think that those industries will be watching this case closely as it will impact their risk assessments that they're undertaking and a review of their working model. That we have already had taxi drivers going through and an employment court finding two employment court decisions that those individual taxi drivers were employees and not independent contractors. So that was a Leota and Parcel Express case. That was a courier driver. Yes. And then we've had taxi drivers, Southern Taxis, where the Labour Inspector brought a case and the employment court found that they were also employees.
There seems to be a real movement to trying to get these employees to be labelled employees. Uber's had this fight in other countries in the world, hasn't it? Just without knowing specifically how each case went, has it generally gone in Uber's favour or not?
Yes, it has. And the 2020 judgment did as well. And essentially in that case, the employment court seemed to be persuaded by the fact that the individual had some business acumen, had reviewed the terms of the contract, and although he couldn't negotiate them, he had previously come from another taxi company and weighed up the benefits of moving to Uber and hadn't raised any concerns throughout the contract time he had a contract on foot with Uber.
Right. So just a stupid question to end the Uber segment. Can you just reiterate why Uber does want to specify its people are contractors, not employees? Why is that?
There could be significant financial implications for Uber. So misclassification, if you've been paying an independent contractor and not paying them holiday pay, taxes, PAYE, we have that system, KiwiSaver, and also there has been, and I'm not sure if this is correct, but some comments made in the media that some of these drivers are being paid less than minimum wage. So there could be wage arrears claims, and all of these claims can be backdated for 6 years under the Limitation Act.
Wow. So Uber could be facing quite a big bill if it goes, not in their favour.
Yeah, and I think Uber has around 6,000 drivers, so it could actually change their entire business model as well, and they might have to have a rethink about how they operate in New Zealand. So it's a very significant determination for Uber.
Absolutely, that's incredible. Now, the regulation of employment advocates. Can you just tell us, employment advocates, are they unions?
No, an employment advocate can be anybody.
Right.
So you don't need a qualification, you don't need to have had any training whatsoever. And they came about because the employment processes are meant to be, the Employment Relations Authority, low level, low cost, efficient, and not, bogged down by lawyers.
Right.
So that's where you had these advocates coming about.
Right. So let's say I have a dispute with my employer. I say, without you being a lawyer, I say, would you like to come along and sit with me and give me some advice about how I might do this? Is that how it sort of works?
That's exactly right. So
Right.
There's a difference between a support person, which could be your mum or your partner or whoever you like, a friend, and somebody that's there to represent you, speak on your behalf, give you legal advice, and that's where employment advocates often provide that service and even hold themselves out in some cases to be employment law experts.
I see. So, sorry, did you say they have to go through special training or they
No
don't?
training.
No training. Okay. So that's interesting. So what has happened in the regulation of these advocates?
So there isn't any.
Right.
So currently there is no body that regulates employment advocates, and what we see in our profession, and there's been statements in the media as well, is that employees in particular, they tend to be the people who use advocates more so than employers, place a great deal of trust and confidence in their employment advocate to give them sound and proper legal advice and assist them through the employment process. But if they don't get that good advice and they are put in a position where they're sort of out of their depth, because sometimes these issues that they're facing are quite complicated.
Right.
There's no right of recourse for them. There's nowhere they can go and complain about the service that they've been provided.
Right. So the Law Society is consulting about how to possibly regulate these individuals.
Yes, they are. Yes. So consultation is open until the 12th of August, and anybody can put forward any feedback. It's open to the public as well as the legal profession.
Could the legal profession be sort of protecting its patch here? Is that possible?
No, I don't think so. The legal profession seems to be more in support of regulation of employment advocates, and that's just about everybody having, it's an access to justice point, and you want to be really working with people who are putting the best, foot forward for their clients. It also increases, our legal costs when we're dealing with really obstructive advocates on the other side who are unnecessarily causing delays to processes, and they're also not bound by a code like we are as lawyers. So, for example, I can't contact directly a represented individual, whereas advocates can contact employers directly even when there's that legal representation.
Okay, that's interesting. So I'm presuming a code of conduct would be part of it, some kind of code of conduct, and maybe some kind of training or some kind of preliminary training?
I think that would be, those two things would be key to any system of regulation.
Okay, that's interesting. Now, additional protections afforded under the Protected Disclosures Act came into force on Friday. Can you tell us about that?
Sure. So the Protected Disclosures Act is a whistleblower act, and so that act regulates and provides protections for individuals who are coming forward with allegations of serious misconduct that they, in good faith, are concerned may be taking place within organisations. So on Friday, new protections came into place, and in particular, serious wrongdoing has been extended to include serious wrongdoing, serious harm to an individual. And in the schedule to that Act, there's a list of examples of concerns, and it lists bullying, harassment and sexual harassment as examples. So with that extended definition, then it is really important for organisations to be making sure that their current protected disclosures policies are fit for purpose.
It's interesting you say that, because doesn't that mean that someone who's being, say, bullied or feels they're being bullied has two sort of legal recourses in terms of pulling their employer up through this Protected Disclosures Act, but also through there's anti-bullying legislation or codes of conduct and things like that, isn't there?
Yeah, so most employers would have a code of conduct, which would include, reasonable treatment or good treatment of employees. And under the Health and Safety at Work Act, there's guidelines around workplace bullying, which defines bullying in the workplace. And obviously, all employers have duties to take reasonable steps to keep their staff safe.
Yes.
So those are two avenues that they can take. However, that second avenue often will require them to disclose their identity, so that the employer can investigate and act on those concerns.
Right.
Whereas under the Protected Disclosures Act, except for a few limited circumstances, confidentiality of your identity is something that is protected under that Act. So it allows people to raise concerns without disclosing their identity, and it also provides that there can be no retaliation or disciplinary processes that come out of coming forward and making a disclosure.
Interesting. So employers are going to have to really bone up on these changes, aren't they? Because they could have a big effect on them.
Yes, yeah, I think that's really important to just review your policies and make sure that you are covering off these new amendments to the Act.
Mary, thank you so much.
Thank you.